Frederica, may I intervene, even though
Of course.
I am blocked in the traffic, and I do apologize with the Center for Civil Liberties and all our colleagues in Ukraine who are listening to us. But I made a mistake in the time difference, so I truly apologize. I'm now stuck in the traffic nearby the Vatican City in Rome. I just wanted to pick up on the issue of the crime of aggression, because I think this is the main aspect of the presentation that I was supposed to do today, and I will continue eventually making use of your time slot in a few days. And the crime of aggression is really the most important crime, regretfully and dramatically, committed in and against Ukraine. It's not only a crime that infringes upon the sovereignty, so the territorial integrity and the political independence of a state, but it's also a crime that has the unique feature of victimizing thousands of innocent individuals who are sent to war illegally by a leader who is not respecting the basic tenets of the international legal order. The crime of aggression has been defined as crimes against the peace in 1945 in the International Military Tribunal at Nuremberg Agreement, the London Agreement of 1945, and has been further defined in 1974 by United Nations General Assembly Resolution 3314, and then on in Kampala 2010 in the review conference of the Rome Statute with Article 8 bis. And it defines the crime of aggression as the most serious and manifest violations of the United Nations Charter prohibition of the use of force, and the manifestation that we see today in and against Ukraine is some sort of a school example of how aggression is, in the sense of occupation of territories, bombardments, attacks carried out through the sea, blockades of ports, and annexation and occupation. So all the features that are listed in the Nuremberg Tribunal Charter, in customary international law, as reflected in Article 8 bis, are taking place on the territories of Ukraine. The most regrettable thing of the International Criminal Court jurisdiction is that in order to appease the United States of America in 2010, the state parties to the Rome Statute allowed to include in Article 15 bis of the Rome Statute an exemption of nationals of states not parties to the Rome Statute in respect of the jurisdiction of the court on the crime of aggression when not activated through a Security Council resolution under Chapter 7 of the United Nations Charter. And in parallel, such an exemption was reinforced by the language in paragraph 4 of Article 15 bis that stipulates that only an armed attack carried out by a state party to the Rome Statute would fall under the jurisdiction of the ICC unless there would be a Security Council referral. So this is really a deviation from the Rome Statute jurisdictional design, which we can find in Article 12, which applies to genocide, crimes against humanity, and war crimes, that, as Frederica correctly presented to your attention, is based on two criteria, alternative criteria, the criteria of territoriality of jurisdiction and the criteria of the nationality or active personality of the jurisdiction. So why this deviation took place? We were coming out of very difficult years of the so-called global war on terror. The George W. Bush administration had waged a war against the ICC in the misinformed perception that the United States of American service members could have been prosecuted by the ICC itself. This didn't materialize, and when President Obama took over, he recreated an environment in which there was fruitful cooperation with the ICC. Nevertheless, an old position remained in the United States policy, which was to try to be exempted from the jurisdiction on the crime of aggression. This was mainly motivated by the fact that in 2003, the United States of America invaded Iraq in violation of the United Nations Charter, in the so-called search of weapons of mass destruction, which were never found. But as the International Court of Justice affirmed already most recently in respect of the genocide case that Ukraine very cleverly brought against Russia, it is not because there is this type of situations that a state may use force against international law. As we know, the use of force is lawful only in self-defense. So if states would enter into the Ukrainian territory to support the efforts of self-defense by Ukraine, it would be a lawful use, of course. If there would be an authorization of the use of force under Chapter 7 of the United Nations Charter and Article 42, or if there was, under customary law, international law, an invitation, a genuine invitation by the territorial state. None of these conditions are met by the current invasion of Russia into Ukraine. And in fact, one can think that the so-called attempted blitz against Kiev in the first weeks of the war after the 24th of February was carried out by Russia with the intent to put up a puppet government that could have created some sort of fake invitation, an ungenuine invitation for the Russian Federation to enter into the territory of Ukraine. Of course, this didn't materialize because the resistance was stronger than the aggressors. So as we speak today, we are facing the imperative to remove from the Rome Statute the provisions in Article 15bis, paragraph 4 and 5 that contains this deviation from the spirit of the 98 jurisdictional regime. And on behalf of parliamentarians for global action, since March 2022, and upon invitation and following an appeal made by 31 members of the European Parliament belonging to all the political groups, PGA, the non-paper that has shared with all the EU member states and with other concerned states that have referred the situation of Ukraine to the jurisdiction of the ICC, in order for them to take decisive action within the next 3 months upon proposal of this, upon deposit of this proposal with the Secretary General of the United Nations, to take decisive action to rectify the jurisdictional regime of the ICC. So far, this proposal has received a lot of interest in a number of governments, and these have been the same governments, some of the same governments, which have been supporting the idea of a special tribunal on the crime of aggression as the one proposed by President Zelensky. Needless to say, this proposal is extremely difficult to be realized, not because it wouldn't be lawful or justified or legitimate or even necessary in the absence of a satisfactory jurisdictional regime on aggression in the face of the ICC today. The problem is more pragmatic, is more logistical. There are, as of today, none of the big European countries, neither the United States, nor Canada, nor others, seems to be willing, at least that is what we understood in private conversations, to support the creation of this type of institution. If you look back at the history of the ad hoc tribunals, you will find out that the ad hoc tribunals were created in the 1990s for Yugoslavia and Rwanda with a Security Council decision. And then at the end of the, at the beginning of this century, with the Special Court for Sierra Leone, with an agreement between the Security Council and the government of Sierra Leone at a time in which the Rome Statute had not yet entered into force. And then there were some experiments, some internationalized tribunals, like the one for Cambodia, that was necessary because the crimes relating to the Khmer Rouge regime dated back to the 1970s. So it was impossible for the ICC to exercise jurisdiction. Other examples are very different in nature and quality, and they may not meet the standards required by the proposal of the government of Ukraine. And there is an overwhelming and prevailing reluctance by states because of the logistical and lengthy preparations for the setting up of such a tribunal, which would require the drafting of a statute, the adoptions of rules, the election of judges, the setting up of premises, the hiring of personnel. And this takes time and efforts. I don't think it's a problem of budget, of course. At the same time, if there was a political will to amend the Rome Statute, a proposal could be tabled now, and a decision could be taken after 3 months of circulation of the proposals. The Assembly of the State Parties to the Rome Statute is already meeting, is scheduled to meet in December 2022. So insofar as a proposal would be tabled by the end of August 2022, the Assembly could take action and adopt the necessary amendments. As of now, as I said, several states have expressed interest and support for this idea, but these states are not yet making the step to deposit the proposal. In our understanding, one main obstacle to this situation is the position of the government of Ukraine, because the position of the government of Ukraine of asking for a new Nuremberg or a new tribunal, as legitimate and important as it is, does not really help the state parties, does not really incentivize the state parties to proceed with this type of reform. In our humble view, and here I activate my video because I finally reach my destination. In my humble view, if the government of Ukraine was able to modify its position, to join the Rome Statute, accept the jurisdiction for good for all the crimes of concern to the international community as a whole, which are 4 core crimes under international law. They are not limited to genocide, crime of aggression, and crimes against humanity. Then, as a state party to the Rome Statute, Ukraine would be in the best possible position to propose the amendments and ask the other states to concur and agree on them. What is very important here is that once these amendments would pass, all the crimes of aggressions that would occur in the future would become justiciable before the ICC, insofar as they have been committed by nationals of state parties or by aggressor states who have not agreed to be bound by the Rome Statute, or by states who have agreed to be bound by both the Rome Statute and the Kampala amendments on the crime of aggression. In other words, our amendment would not fix entirely the jurisdictional regime of the ICC. It's a modest proposal because it would still require for the member states like the UK and France or that did not yet ratify the amendments to take their time and then join at a later stage when they will deem it appropriate for them, and then accept the jurisdiction for their own nationals and territories on the crime of aggression. This type of two-tier regime, however, was already envisaged in the Article 121.5 adopted at the Rome Conference. So as unequal and asymmetric as it is, however, the law. And as we know, as the Romans used to say, dura lex sed lex. Sometimes the law does not correspond to an ideal of justice, but we need to apply the law and make it happen, make it a livable, a living feature, and then work towards its reform. So that's the goal of our proposal, to make a first reform, eliminate from the Rome Statute these awkward exemption for states non-parties to the Rome Statute jurisdiction of the crime of aggression, which would capture finally Mr. Vladimir Putin and all his main accomplices who have, in our view, unlawfully launched a war of aggression against Ukraine and the Ukrainian people, by also causing the death of thousands and thousands of Russian victims of the war of aggression, because the soldiers are not protected by international humanitarian law. The soldiers are lawfully killed by the Ukrainian resistance in the armed conflict. Yet they are victims of the criminal war of aggression launched by their leader, who sent them to die against international law. Similarly, the Ukrainian soldiers who are dying in the Donbass today in the cause of the defense of their own country, they are not victims of war crimes, because whether we like it or not, under international humanitarian law, they are lawfully killed by the enemy combatant. Yet, they are victims of the crime of aggression. They are dead because of the unlawful decision of one or more leaders who have decided to launch an illegal war against a sovereign nation. So that's the importance of the crime of aggression. The crime of aggression allows us to cover and to protect the interests of those who are not covered or protected by existing international humanitarian law. Let's go back to Nuremberg 1946. The crime of aggression was the main crime prosecuted and adjudicated before the Nuremberg Tribunal. Yet the Nuremberg Tribunal applied the law only to the Axis power, was not mandated to apply the law to all the sides of a conflict. After the end of the Cold War, this was a major change. Each and every tribunal, each and every jurisdiction that was set up by the international community applied the law, at least in theory, equally, but that's not always, that has not been always the case, as correctly so, to all sides of the conflicts, because international law applies to all sides of the conflicts. Yet, in this conflict, only one side committed the crime of aggression. One can also argue, also only one side might have committed the crime of genocide, for example, in Mariupol. No doubt about it. I support that view. It has to be proven before a court of law. And I hope that the ICC will take up on this challenge of trying to prove the crime of genocide against the Ukrainian and other groups living in the city of Mariupol that was totally destroyed under a siege that violated each and every norm of international law. And there are other examples that you can do much better than me, because you know your country much better than I can from the public information and the media that I can read. But I think that the main crime committed in and against Ukraine, it's the one that was launched on a full scale on the 24th of February, and it's called the crime of aggression. We are in a World War II type scenario. And I think it would be a wise decision for the president to change his mind, as he did by sacking the general prosecutor, I believe yesterday. He can also change his mind on a substantive policy issue. And I understood there was this policy issue to suspend any process towards the ratification of the Rome Statute. In our view, on behalf of parliamentarians of global action, we sharply disagree with this type of decision. Because the advantages that Ukraine can receive from being a full party to the Rome Statute, including by activating fully the court's jurisdiction on the crime of aggression, largely supersedes any possible negative aspects that may be stemming from such a ratification. I would also argue that those who characterize as negative the fact that some Ukrainian nationals could be under the jurisdiction of the court, I would characterize this as an advantage, because it would show that Ukraine fully abides to the principle of complementarity, is able to adjudicate its own nationals, and it's a country that is fulfilling its duties under international law, ready to sit in the main table of the international community, ready to become a full member of the European Union, ready to exercise a moral authority that, in my humble view, and here I'm speaking as a European citizen, not as a Secretary General of Parliamentarians of Global Action, in my humble view, could persuade so many Russian citizens to drop their support for their current leader and move their ideas and ideals in the camp of democracy, human rights, and the rule of law. Nothing is written in stone. Also, Russia and the Russians deserve a democratic government. And we know it very well. The Ukrainian regime with all its difficulties, deficiencies, and challenges, was and is a very democratic government. And for Russia to have such a strong democracy at its borders was something almost intolerable. That's what it transpires from the speech of President Putin that he delivered in July 2021 in Moscow. So I think these ideologies, this nationalistic ideology, can only be defeated if Ukraine is able to fully and consequentially abide to the letter and spirit of international human rights treaties, the International Covenant on Civil and Political Rights, and show to our Russian friends and brothers and sisters who are human beings like us and they deserve the same human rights as we do, that there is a chance for change. There is a possibility for change. So I want to really close this intervention on behalf of Parliamentarians for Global Action with an optimistic view, because this war is creating enormous victimization. This war is characterized by enormous suffering, but it is absolutely the beginning of the end for a nationalistic criminal regime of the Russian Federation that may not be allowed ever again to conduct business as usual with the West and with the rest of the world. The main challenge now, and we take upon ourselves on behalf of PGA to work on this, is to persuade the developing countries, the Latin Americans, the Africans, some of the South Asians, that if you want to be on the right side of history, you cannot be siding with the aggressor. You need to be siding with the victim of aggression for the rule of law and international law to prevail. So this is something we will continue to do. And we do believe that an indictment, an arrest warrant against Mr. Putin or other leaders responsible for the aggression could be the best starting point to isolate him, marginalize him, create the condition as with President Omar al-Bashir, that after a number of years, he would be more easily, let's say, put aside by those in power in his own country and in the international community. Thank you. And I know there are questions, but I am speaking from a phone, so if you can dictate them to me, I will very be delighted to answer them. And I will also be available when my colleague Frederica has her own lecture, because I owe her to help her in conducting also that one. Thank you.
Yes, thank you. We have, thank you. First of all, thank you for your strong position and strong voice on this matter. We, as Ukrainian citizens, as your Ukrainian colleagues, we appreciate your position very much. And we have two small questions. The first one, how to make Russian political and military leadership accountable when Russia uses the advantages of the UN system, the right for a veto in the Security Council, but at the same time disrespect other norms of UN statute?
I think what we have at the United Nations is really an unacceptable situation, whereby there is a permanent status of violation of the UN Charter. It's an illegal act. What happened already in and violates the UN Charter itself. So what happened in March is already very important, in that automatically every Security Council resolution on international peace and security that would be subjected to a veto, automatically the subject matter in question will go in the agenda of the United Nations General Assembly. Unfortunately, the United Nations General Assembly does not have any binding powers, so it can only issue recommendations. But when reaffirming principles and norms of international law, we have seen the General Assembly, like when it adopted the Genocide Convention, it can really dictate legal principles that can align the respect of the rule of law worldwide. So we should maximize the use of the General Assembly. And this is why it's so important to persuade the developing countries, to persuade the Africans, the Latin America, and the South Asians, including also the Arab states, that the right way to go is the respect of international law and not alliance with the Russian Federation. In the long term, I'm optimistic, but now some challenges are really facing us. And I think the more the Ukrainian state will be able to resist, the more it will indicate to the rest of the world that wars of aggressions cannot be a viable solution to controversies. There could have been any controversy whatsoever between Russia and Ukraine, but never the use of force would be justified under international law. So I think if we are able to make this very clear point, then the next step will be that the global alliance in support of Ukraine will expand and not diminish. Ultimately, the problem of the UN Charter is that unlike the Rome Statute, which can be amended by a majority of states, regretfully in the UN, if you don't have the permanent five in agreement with any proposal for amendment, such a proposal cannot be even discussed. So essentially, the UN Charter is a non-amendable treaty. Ultimately, if this situation persists, but I hope not, because I've seen already as early as mid-June, China delinking itself from the Russian position, at least on Ukraine. Regretfully, however, India continued to side with Russia, which is very regrettable. In any case, I think ultimately, in the long term, the only project to be fulfilled would be to have a new UN Charter to replace the old one. But I mean, this is really the jure condendo. This is really about how the law should be in the future. For the moment, let's make use of the instruments that we have. And one of the instruments that we have is a treaty, the Rome Statute, that can be amended if there was and if there is political will.
Thank you, David. And please, the last question. How do you personally envisage the future court process on Russian war criminals? ICC or a separate special tribunal?
I think the question refers to the other core crimes where a lot of work is going on, correct? So war crimes, crimes against humanity, eventually even genocide. And as I believe that, for example, in Mariupol, as Professor Flavia Lattanzi already wrote, she was the fourth judge in the Karadzic trial and convicted Mr. Karadzic for the genocide in Srebrenica. She believes that if the facts on the ground can be proven, there are all the elements for a similar scenario of genocide like in Srebrenica, also in Mariupol. But let me tell you, here it's really up to the way the Ukrainian domestic legal system prefers to organize itself. Organizing itself, receiving also international cooperation, setting up what normally people call an hybrid tribunal or what I would call an internationally supported chamber, in addition to its own domestic courts. That would be maybe a very important step because it would demonstrate that Ukraine is fully open to international cooperation. Necessarily, all the vast majority of the cases will need to be heard before this type of tribunals, either the ordinary ones or an internationalized mixed hybrid one that Ukraine might create within its own jurisdiction. It would still be a Ukrainian court, and make no mistake, because there is no middle way between an international court or a domestic court. Hybrid courts are still domestic courts, in my humble view, because their legitimacy stems from the constitution of the state within which are created. Otherwise, if the legitimacy and the source of law comes from directly public international law, you have to have a treaty or a Security Council resolution setting up such a tribunal, or an agreement, which can be a treaty between the United Nations, its General Assembly, for example, and its Secretary General on behalf of the Assembly, and the state in question, as it happened between Cambodia and the United Nations for the Extraordinary Chamber. So, but if we don't have this type of institution making, whatever we call international is not really international. It's actually a part of the Ukrainian legal system, yet receiving a lot of international support, so we can qualify it as an hybrid tribunal. I see this as the major avenue, with the ICC only taking the cases against those individuals that are maybe found in countries from which Ukraine cannot obtain the extradition, or who are protected by Russia itself, and they may remain fugitives of justice for many years. Because having an international arrest warrant carries a stronger political weight and also a stronger legal weight, because the Interpol, for example, can issue a red notice, and there are other avenues through which the ICC can make its own voice stronger than any individual state. If Ukraine would have been a member state to the ICC, then it could have used all the features within the Rome Statute system to obtain the cooperation of the ICC itself and of state parties. Now, everything has to be done ad hoc, through special laws, through special agreements, through the will of the government of the day. No one doubts that the government of the day wants to fight impunity, but why not to institutionalize the membership of Ukraine in the ICC? So President Zelensky, we are asking you, change your mind, move away from this position that has been misguided and misled. Probably some of your former advisors who have been sacked have been unduly influenced by the positions of Professor John Bolton from the United States, who was an advisor to Mr. Trump, who had ideologized a war against the ICC during President George W. Bush. And in the end of the day, just read the US Senate resolution in support of justice for Ukraine. It's a bipartisan resolution. It recognizes the ICC. It recognizes the crime of aggression. It is fully supportive of international and domestic justice with no caveats. So the US position has changed. There is no reason to invoke the US non-membership in the ICC for Ukraine or another middle power not to join it. And a final point that I want to make here, coming back to the Security Council question, is that Parliamentarians for Global Action supports the initiatives of a number of states, including France and Mexico, including Liechtenstein, Estonia, Costa Rica, and several other states in the ACT group, to have a code of conduct that would be softly, let's use this non-legal terminology, softly binding or commit politically states to refrain from the use of the veto or to oppose any Security Council resolution that would address mass atrocities. So coming back to that question, it would be, I know that Ukraine is already party to that group of states, but the current crisis is highlighting the need for all the other states to join. So also that tool can be advanced. It was developed in the face of the failure of the international community to make accountability work in respect of Syria, which, by the way, incentivized Mr. Putin and its allies to now commit the crimes in Ukraine. Because when they saw that there was no consequences for the massacres against Aleppo and all the other major cities of Syria, they started to think that, well, if we have impunity there, we will have impunity everywhere. So I think that what is happening now on accountability and justice for Ukraine will be a major turning point in the history of the international community. And I do believe that the entire international community must be grateful to the staunch resistance of the Ukrainian people. You are defending the values in which we all believe. And you know, I cannot describe the suffering and the pain and the harm that is being caused by this war. At the same time, I hope that there will be a moment in which history will be written, and this will send finally a message that not only Nazi fascist regimes, not only communist regimes, but also hyper-nationalistic regimes like the one of Mr. Putin must be stopped from the start, must not be appeased with business, with energy contracts, with all the global economy benefits that stem from his repressive regime in the last 20 years. We need to learn from the mistakes of our recent past. And it's tragic to be saying this when Ukrainian people are being killed every day. But I really want to believe that this will be the last of the wars of aggressions done in the name of hyper-nationalism. So I hope that we will be writing this page of the history together. And I really hope that all the countries of the world, not only those in the European Union or those who are already allied in NATO or in Japan, Australia, and so on with Ukraine will come together and unite their forces for the rule of law, for human rights, and for a principle of just peace. And if I can make a small announcement here, Parliamentarians of Global Action will organize on International Day of Peace, the 21st of September, an online conference on the victims, on defining and identifying the victims of the crime of aggression. Because we want to come out of that false myth that the crime of aggression is only victimizing the territorial integrity or the political independence of a state. No, the crime of aggression means that real people die and suffer every day. So I invite everyone to join, and we hope to have one of the leaders of the PGA group in the Verotna Rada to be among the speakers. There will be the special advisor to the ICC prosecutor on the crime of aggression, Professor Dr. Klaus Kress. And we hope to have some others, for example, a speaker from South Korea who will testify what happened during the aggression of the Korean Peninsula during the World War II, and how things have been developed after that. So there is a lot of work to be done. But if out of this week on international criminal justice, the Center for Civil Liberties, the initiative A Tribunal for Putin, the Kharkiv Center for Human Rights, and all the fantastic NGOs that populate the civil society of Ukraine, if you can unite your voice to persuade President Zelensky to change his mind, as he did when he removed from crucial offices certain individuals who might have not been the ideal ones for the position, we submit humbly that this position, not joining the ICC, is also not ideal for Ukraine. Then I think we would have accomplished a small step in the right direction, and then be ready to reform the Rome Statute and ensure that the crime of aggression become an active part of the jurisdiction as early as 17. I think from a legal point of view, it can be done as early as 17 July 2018. Thank you very much.
Dear David, Federica, thank you for your presentations and for your strong points and advocacy for the more just world, for the international criminal justice system, for the ICC, for a world where even the leaders of the state will be held accountable for the most grave human rights violations. And on this note, I will also say that today at 5 o'clock Kiev time, we will have a short comment online from Sir Howard Morrison, a former judge of the ICC, who worked there from 2011 to 2021. And dear viewers, don't forget to step in to the live stream at 5 o'clock. And tomorrow we will speak about transitional justice. We will speak about perspective of transitional justice in Ukraine and what have changed after 24th of February. Thank you all, and I hope for a great partnership this year with you. Bye.
Thank you very much.